Hello, welcome to Lecture 2 from Topic 3, where we can continue our exploration of the incorporation of the Bill of Rights. You may be asking yourself, why study incorporation? And is it really important? Like, what do we learn from studying incorporation? And I just want to, sort of make a case for why it's important to study incorporation. Not that it's just not fundamentally interesting, it is, but I get that it's a little bit dry, and we're going to be moving on to like the actual civil liberty cases next week, so that'll be great. And so it's important to study incorporation because, sure, we get to learn when, how, and why liberties became comprehensively applied to the states. And we also learned that for nearly over 100 years of our country's history, the Bill of Rights didn't apply to the states. So there's a historical sort of aspect to why this is important. But there's another aspect that I want you to keep in mind about why studying incorporation is important. And it's important because it gets us thinking about what are, in fact, liberties that are fundamental to a democratic and just society. We're going to see in this lecture that when the court finally decides that the Bill of Rights should be incorporated to the states via the Due Process Clause of the 14th Amendment, the way that they start incorporating those liberties is, one, they do it liberty by liberty, and they ask themselves, is this particular liberty, freedom of speech, the right to practice religion, a right to a grand jury trial, the right to a jury trial. They ask the question about, are these liberties fundamental to a democratic and just society? And that's what they are asking. And so it gets us thinking about what liberties are just so fundamental that without them, you really can't live in a democratic society. It also gets us thinking about how we answer that question, how the answer to that question has changed over time. Because in the 1930s and 40s, as liberties begin to be incorporated to the states, very few are incorporated to the states, very few liberties. Freedom of the press, freedom of speech, freedom of religion. Only a few are identified as fundamental or essential liberties. But today, almost all of the liberties are seen as essential. And so it gets us asking the question, are all of the liberties in the Bill of Rights essential? Are there some that really don't ever need to be incorporated to the states? And also it gets us asking the question, when we're talking about fundamental liberties, are there any that are actually missing from the Bill of Rights? Because remember, when we think back to James Madison, when he was writing the Bill of Rights, he thought it was sort of a nauseous affair, right? It made him sick to his stomach because he wanted to make sure that no liberties were missing, right? Once you write them down, you assume that those are the ones that are fundamental, but it cannot be an exhaustive list. And so in several weeks, we're going to be learning about the right to privacy. And the right to privacy is not enumerated, it's not expressly stated in the Bill of Rights. And there's still a question today about whether or not the right to privacy is actually a right that is constitutionally protected. Also think about, while that at least right now the right to privacy is constitutionally protected, it may change in the future. There are other things like the right to obtain an education, right? I mean, you have a right in the Fifth Amendment that your property can't be taken from you by the government. Is it by the government not giving us an education? I mean, does that mean that they are basically taking something from us that is not enumerated in the Bill of Rights? So just something to keep in mind as we are sort of studying incorporation and why it's important to study. Okay, so just as a quick refresher, I know you just watched it in the other lecture, but in case you took a day or so to get back to that, I just want to do a quick refresher and remind you of the 14th Amendment and the clauses that are in the 14th Amendment. Remember, we have one clause called the Privileges or Immunities Clause, and it says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And as we're going to see, it's been left to the court to define what we mean by privileges and immunities. And the Due Process Clause that says that nor shall any state deprive any person of life, liberty, or property without due process of law. And so we're reviewing these because these are the two clauses that are targeted for people who feel like their liberties are not being protected and being tread upon by the government, these are the two clauses that they look at to say, you know what, the Bill of Rights should apply to the states. So let's go ahead and get started. All right, let's start with the Slaughterhouse Cases from 1873, otherwise known as the Privileges or Immunities Clause. Path to incorporation is a dead end, same as the cows, sad face emoji. Because this is a case, the slaughterhouse case. These are cases having to do with the slaughtering and the butchering of animals. Not really, but we'll, that's part of it. So this is a case about butchers that feel that they were deprived of the right to conduct business by the state of Louisiana. That in New Orleans and outside of New Orleans, that in New Orleans is along the Mississippi River. And so in New Orleans, there was a lot of slaughterhouses that were, along the river, and that they were throwing all of the entrails and blood, what have you, into the Mississippi River as a process of the slaughterhouse. And since these were all owned by different butchers, and that, there wasn't really any law that was sort of regulating their activity. So Louisiana passed a law that restricted slaughterhouse operations in New Orleans to a single corporation. It created the Crescent City Livestock Landing and Slaughterhouse Company. And it was basically a monopoly. It received a monopoly to run a slaughterhouse downstream from the city, and all other butchers that were setting up shop, they couldn't set up shop anymore. That they could work as butchers, but they would have to work as a part of this corporation. And so the butchers were pissed off. They felt that their right to conduct business was taken away from the state by the state of Louisiana. And they said that that's not fair. And so they sued the state of Louisiana, and they used the 14th Amendment's Privileges or Immunity Clause. They were looking for remedy for this, what they felt was an unfair deprivation of their right to do business. They looked to the Privileges or Immunities Clause for a remedy. They were basically saying that the right to do business is a privilege or an immunity that all people have and states can't take away from you. The courts ruled against the butchers in this case. They said that the Privileges or Immunities Clause that's in the 14th Amendment was really narrowly written. It was written in a way to protect the rights of former slaves. Remember, these are the Civil War amendments. And that this clause was not in the Constitution in order to extend expansive rights as listed in the Bill of Rights to all citizens. And so this was the first effort to incorporate the Bill of Rights, and it fails. And in fact, as your textbook points out, the Privileges and Immunities Clause is just sort of gutted at that point forward. It really has never been used legally in the United States, and it certainly hasn't been used for the incorporation of the Bill of Rights. So the Privileges and Immunities Clause was not the avenue for incorporation. The Due Process Clause was the next avenue taken for the effort to incorporate the Bill of Rights. The big question is will the court use this clause to incorporate the Bill of Rights? And if yes, which liberties will be incorporated? Okay, so let's take a look at these series of cases that help us get an understanding of how the court is willing to use the Due Process Clause to incorporate the Bill of Rights to the states, but is still sort of not having sort of a clear guidance for which liberties will and will not be incorporated. So you've got three cases here: Hurtado versus California, Chicago, Burlington, and Quincy Railroad versus Chicago, and Maxwell v. Dow. And all of these are important because it tells us about the pathway to incorporation. Hurtado v. California is an interesting case. It's about a guy, Joseph Hurtado, and his wife, Susie, and a guy moves into town. They live in California. His name's Jose Estuardo. And Jose starts hitting on Hurtado's wife, Susie, and Joseph Hurtado doesn't like that. And so he tells him to cut it out. He doesn't cut it out. He moves his wife down to Mexico to get her out of the way. But Joseph is still really pissed off about it. They get in a fight in a bar. And then later on, when he's out on bail, he ends up killing Jose Estuardo. And so what does that have to do with the incorporation of the Bill of Rights? Well, when Joseph Hurtado was charged, um, he was charged for murder. He was charged using a preliminary hearing, not a grand jury. A preliminary hearing is, where you basically, the prosecutor brings evidence that a person should be charged with a crime to a judge, and the judge determines whether or not you should be charged. In the Fifth Amendment, it says that you have a right to a grand jury. And that means that if you're going to be charged with a crime, a prosecutor actually presents evidence to a jury of people, a big jury, a grand jury. And the jury determines whether or not that person should be charged. And so because Hurtado was not afforded the right to a grand jury, his attorney said that that there should be a mistrial because he wasn't properly charged. And so that question comes to the court, and the broader question is, is the right to the grand jury trial in the Fifth Amendment, does that apply to the actions of the state of California? What they find in this case is that that the due process clause can be used to incorporate liberties to the states, but they have to be fundamental liberties. They have to be liberties that are essential to a democracy. And they find that the right to a grand jury, that it's a liberty in the Fifth Amendment, but it's not one that's fundamental, and therefore it doesn't need to apply to the states. Okay? So that's a really important case because it opens the door for the due process clause to be used as an avenue of incorporation. The Railroad v. Chicago cases has to do with the eminent domain. Now, remember back to Barron versus Baltimore. That was a case where the city of Baltimore messed up John Barron's wharf, and he felt like he deserved compensation for his property being taken away. And remember, the court said no, the Fifth Amendment doesn't apply to the states. This is basically a revisitation of that question, and the outcome is the polar opposite. In this case, they said that the due process clause can be used to incorporate the Fifth Amendment's just compensation, the takings clause, to the states. And the reason is because compensation for property taken away is a fundamental liberty, that we can't live in a democratic society if government takes your property without giving you just compensation. And so it's an important case because it's the first one that incorporates a liberty to the states. And then finally, we have Maxwell v. Dow. And this is about Gunplay Maxwell. He's a bank robber. He robs a bank in Utah, and he's tried by a jury of 8. The state of Utah has a law saying that for non-capital offenses that you can get a trial, but not by the usual 12 jurors. He was tried by a jury of 8 and was convicted. And so Maxwell's attorney said, wait a second, his Sixth Amendment rights to a jury trial has been violated. The court took that up, and they said that in this case, trial by jury is not a fundamental right to be incorporated to the states, okay, via the due process clause. And so you can see that there's some sort of like confusion here, maybe like, okay, grand jury is not a fundamental liberty, but compensation for property is, but trial by jury is not. When that happens in the Supreme Court, usually the Supreme Court tries to develop a test that will give us guidance in terms of which liberties should be incorporated to the states. So let's look at the development of the test. All right, let's take a look at the next 3 cases, and I'll just again put these all up here, and then we will talk about them individually. You've got Twinings versus New Jersey, Gitlow versus New York, and Palco v. Connecticut, which we'll talk about in more detail on the next slide. Twining is an important case because it provides the outlines for the test that's going to come in Palco. In Twinings, this is a case about self-incrimination and whether or not a judge can tell the jury to take into consideration the fact that somebody refused to take the stand and refused to testify, sort of assuming that this person was guilty because they didn't take the stand. And so in Twinings, they say that some liberties are fundamental and will be incorporated to the states. So we kind of know that from the previous cases, but it's going to happen on a case by case basis, a liberty by liberty basis. And so this is an important case because it tells us that the due process clause is going to be used, but it doesn't totally incorporate the Bill of Rights to the states. In other words, all of the liberties that are in the Bill of Rights are not immediately or totally going to apply to the states. Instead, it's going to be selective incorporation. That is, that each liberty has to come to the court. The court has to determine whether, in fact, it's fundamental, and they will determine whether or not it will apply to the states. And selective incorporation is the way that the Bill of Rights has been incorporated to the states. Gitlow adds on to this. It identifies two liberties that are fundamental: speech and press. Gitlow is a case about a socialist who writes a manifesto called the Left Wing Manifesto that calls for the establishment of socialism and encouraging people to strike and take action against the state. And Gitlow was charged with violating the New York State's criminal anarchy law. But he said that what he was saying was just political speech, that he wasn't trying to incite violence. Sounds familiar, right? And when we get to the speech section, we're going to be reading a lot of cases about socialists who are charged with inciting violence. Gitlow, they say that the state can prohibit Gitlow's speech. They did think it was not political speech, but it was speech that was designed to bring about violence. But Gitlow's important because it says that speech and press are fundamental liberties, and they should be incorporated to the state. And then it's finally in Palco v. Connecticut that the court defines what are fundamental rights, and the Palco test is the one that is used to incorporate all of the liberties to the states. So let's take a look at the Palco case. So let's look at Palco v. Connecticut and why it's an important case. A lot of the cases that you read over the course of the semester, particularly the criminal, when we get to the rights of the criminally accused, they're kind of depressing cases. And this case is no exception. This case begins in Connecticut when Frank Palca, they misspelled his name in the case. That's not unheard of. That's happened several times in some of the cases we've read this semester, and will continue. Frank Palca, he robs a convenience store or a liquor store, I think, and he shoots and kills two police officers. So he goes in for a robbery and he ends up killing two cops. And he confesses to shooting the police. And then he is tried for first-degree murder, but in that trial, the Connecticut judge refuses to admit his confession. And in the absence of that evidence, that Frank Palco was convicted not of first-degree murder, but of second-degree murder, still very serious, and life imprisonment. Why this is an important case is because the prosecutors didn't like that outcome. They thought that the judge should have admitted that evidence of the self-confession, and they got a court to agree with that. And so the court issued a retrial, allowing the confession to be used, and that this time Frank Palco was convicted of first-degree murder, and he was sentenced to death. The question before the court was this double jeopardy, right? You can't be tried twice for the same crime. And the Fifth Amendment, again, prohibits that double jeopardy. And so in this case, this is an important case because it gives us the standard that's used to incorporate the Bill of Rights to the states. So it's called the Palco test, right? And it's the one that was used to incorporate nearly all of the liberties. That's because they tell us what is a fundamental right. They say that a fundamental right is that all fundamental rights should be applied to the states. And what fundamental rights are principles of liberty and justice, which lie at the base of all of our civil and political institutions, the very essence of a scheme of ordered liberty rooted in the traditions and conscience of our people, and that neither liberty nor justice would exist if they were sacrificed. And so that is in 1937, the court basically develops a test that is very includes a lot, and that gives lawyers and future courts the ammunition that they need to incorporate the Bill of Rights to the states. Because you could say this liberty is one that has been rooted in our tradition, the traditions of our people. It's in the Bill of Rights. It should go to the states, right? That to say that something like a jury trial is at the basis of our civil and political institutions, et cetera, et cetera. So it's an important case because it gives us the test. But unfortunately for Frank Palca, in this instance, they said that double jeopardy is not one of those rights. They didn't really even consider this like a double jeopardy case. They sort of felt like the second trial was a continuation of the first trial. Now, that's not how it would work today. Double jeopardy that would be double jeopardy. But they were basically like, yeah, it was an error. Hey, go back, admit the evidence, and convict. Also, keep in mind that when it comes to liberty, it's a lot easier to take liberty away from those who kill cops, who kill their friend because they're hitting on their wife, right? We're to see in the Duncan case, who maybe hit somebody, right? Although in that case, I mean, it's clearly racial bias that's going on. And so, those who are most likely to have their liberties taken away are the criminally accused. So when we sort of see that trend early on, though that trend stops in the 1960s under the Warren Court. And so this is the test that's used today with some additions that you'll see in your textbook. So make sure that you read about those additions, in particular the additions about the Duncan case. And as we know, nearly all the rights in the Bill of Rights have been incorporated to the states. And here we have just a diagram. It's from your textbook that does a really good job of showing the pathway of the incorporation and just how gosh darn long it's taken. And so it's divided up by the amendments. And so you can see that like the First Amendment has lots of different liberties in it. Speech, assembly, petition, religion, an establishment of religion is free exercise as well. And then it shows you the cases. So a lot of these cases we're going to be talking about as we move forward this semester, like Cantwell versus Connecticut, Everson versus the Board of Education, and Gitlow versus New York. Gitlow versus New York. I won't go through it all. You can take a look at it in your textbook, but just take a look at it. And this actually is already out of date. So here they have the last liberty that was incorporated to the states was the right to bear arms in McDonald versus the city of Chicago. That's the follow-up case to DC v. Heller. And the Second Amendment was incorporated to the states in 2010. But since then, when you look down at the Eighth Amendment and it says cruel and unusual punishment has been incorporated to the states, that's true. But at the time that the textbook was made, the excessive fines clause of the Eighth Amendment had not been incorporated to the states, but it is today. So in 2019, in a case called Timms v. Indiana, the excessive fines clause of the Eighth Amendment was incorporated to the states via the Due Process Clause. So here's just some questions for you to think critically about incorporation. So the court has incorporated the liberties, the Bill of Rights, liberty by liberty. They've used selective incorporation. Do you think selective incorporation is a better approach than total incorporation? In other words, is it really necessary to incorporate all of the Bill of Rights to the states? Does it make sense? Does it give us some insight too in terms of the meaning of liberty if we go liberty by liberty? Or is there a downside of that? I mean, there's definitely a downside for somebody like Frank Palco, right? If we had totally incorporated those liberties, then double jeopardy would have been incorporated unequivocally. But it took until 40 years later, about 30 years later, for double jeopardy to be incorporated. And so it has going selectively can have real consequences on people's lives. You're also going to see that a lot of incorporation took place, particularly for the criminally accused, in the 1960s during the Warren Court, which was a very liberal court, liberal in terms of protecting individuals from the power of the government treading upon their personal freedoms. I was sort of thinking, given we've had a conservative courts for a while, Rehnquist and now the Roberts Court, very conservative. do you think a conservative court, or even like, let's say that the rights of the criminally accused had not been incorporated during the 1960s, do you think our current conservative court would incorporate the rights of the criminally accused if they had not been incorporated in the 1960s? Do you think that they would have found something like the freedom, the right from self-incrimination to be a fundamental liberty? Do you think that they would find the exclusionary rule a fundamental liberty, and others? So just something to think about as we bring incorporation to a close. All right, so you made it through, or you're in the process of making it through the third of the fundamental chapters, right? So finally, next week, not that we haven't already started it because we're already talking about liberties, right? But now we actually start the First Amendment next week. And so, and we start with not speech, not assembly, not press, but we start with the freedom of religion, because that is actually the first liberty that is identified in the in the First Amendment. The right to exercise your religion and the right to be free from the establishment of religion. Woot! So I'm looking forward to that. And thanks for sticking it through these first three chapters.